There is, however, this view from other academics, other scholars, who think that delaying the impeachment to when session resumes in June 2 might frustrate both the word forthwith in the Constitution and also principles of accountability. And I think I was in a conversation with Justice Vivi Mendoza on this, where he says that the great battlefield of constitutional law today is the meaning of the word, or is the word forthwith. So I wonder what your thoughts would be in relation to that. Would delaying impeachment actually result in frustrating accountability?
You know, to resolve that question, I have asked the President to call a special session. Even if you don't include as an item in the special session the impeachment trial, the Constitution provides that the Senate that the impeachment trial shall take place forthwith in the Senate. So even when as a reality, when the President calls the Senate into a special session, the first item on the agenda is consideration of the impeachment complaint filed by the House. And that will be referred to the impeachment court. And then you start the impeachment trial. So I strongly believe that when the President calls for a special session, the impeachment trial immediately takes place because of the mandate of the Constitution.
Thank you, Senator Dillon. Justice Carpio Morales?
According to Black Dictionary, forthwith means immediately, at once, but it also considers reasonable delay.
Some of the senators, current senators, are running for re-election. To me, these constitute circumstances that can abate the use of the word forthwith. Thank you.
Thank you, Justice. Prof. Gwen, Prof. Ted.
Thank you, Justice. My understanding of the word forthwith used in the Constitution is not just immediately, but also a sense, as Justice Carpio Morales pointed out, reasonableness, that it means avoidance, undue delay. So that if the action of the Senate is not animated or motivated by imposing undue delay in commencing the proceedings, I think they would well be in compliance with the constitutional mandate to proceed with the impeachment trial forthwith.
Thank you. Prof. Ted.
As litigators would know, often when you go before a court and ask for time, the court will usually ask you if you're trying to delay the proceedings. So the question of forthwith, I think, also goes into motivation or intent or things that you can foresee or cannot foresee. So I would agree with Justice Carpio Morales that while it would mean by ordinary meaning, immediately, but it also takes into account circumstances. It also takes into account reason, and it takes into account things that the Senate cannot control, like the recess. The objective circumstances being that the transmittal was made on the last day of the session, and they had gone into recess before they had referred it to the impeachment court. Therefore, that may constitute, even though there is a span of time that intervenes, that may constitute reasonable delay, as it were, and would not frustrate the meaning of the word forthwith.
Commissioner Sarmiento, I'd like to ask if you have a response to these views.
I see the wisdom of the responses of Senator Frank, Justice Carpio, and my co-panelists. What I mentioned in my presentation, this is a very novel addition in our history as a people, not even found in previous constitutions and many constitutions of the world. Very unique provision in the Constitution. Traditionally, yes, on recess cannot be, unless the President calls for a special session. But this is a novel addition in the Constitution. And in the light of the intention of the framers of the Constitution, na walang patumpik-tumpik, umpisan kaagad. Because it's a time-compelling, significant activity in our country. Accountability, checking abuse of powers, etc., etc. then to me, I would say that regardless of the recess, a time impeachment trial should begin in the light of this constitutional provision.
Yeah. I cannot accept the proposition that simply because the senators will be campaigning such an important and critical constitutional duty to constitute itself as an impeachment court and try the impeachment complaint can be deferred. Firstly, the Constitution says shall be tried forthwith. And we give ordinary meaning to ordinary words. Forthwith means immediately. And it is my respectful submission that the campaign period is not a valid reason to postpone. And in fact, there should be no circumstance to justify a deferment because the Constitution mandates the performance of a constitutional duty forthwith. The only reason why we need a special session is the formal referral of the impeachment complaint to the impeachment court.
Thank you, Senator.
Mr. Tamase, may I make a follow-up? We have in constitutional law the doctrine of constitutional supremacy. All laws, all regulations, all contracts have to yield to the supremacy of the Constitution. I think all lawyers would know that doctrine. So if recess is a legal provision, it is a provision in the rules of the Senate. They have to yield to the command of the Constitution about forthwith proceed.
Thank you, Commissioner Sarmiento. I understand it may have also been in line with the innovations in the 1987 Constitution to make it.
To preserve constitutional government, to preserve the order in our country, to avoid chaos. So to me, the lowering is very relevant to this forthwith proceed provision in the Constitution.
Thank you, Commissioner Sarmiento. I think the reason why, Justice, thank you. Would you have a response to this question, to the points of Commissioner Sarmiento? Thank you, Justice.
I'm going to respond to the fact that, wait, the Hello Garcia case, Hello Garcia, I'm sorry. The Supreme Court said that the Senate is a continuing body. It's a continuing institution. But the discharge of its day-to-day normal functions, it is independent of the predecessor. In other words, it's not bound by what the preceding Congress Senate did. So any unfinished matter can be considered as if it's set for the first time. Thank you.
Thank you, Justice Chit. I think that brings us to the second question, which ties into the urgency of the impeachment or the sense that the Senate should proceed immediately. Can you please flash the next question? So the second question, and I think it ties into this concern that if the Senate does not meet now, when it is on recess, then there might be a frustration of the impeachment trial, because another question that keeps coming up is that may the impeachment trial carry over from the 19th Congress to the 20th Congress, when I think I understand from Garciliano and the older case of Arnott, the Supreme Court said that the Senate is a continuing body, but then we have this more recent case of Balag where the Supreme Court now says that Congress or the Senate's business does not continue beyond a Congress. So your thoughts, Justice Carpio Morales or Senate President Drilon, on this?
Well, I'm not the Supreme Court, but I maintain my position.
Thank you, Justice. Senate President Drilon.
To me, this is an open question. Can the impeachment complaint filed in the previous Congress be continued when the new Congress comes in and the new impeachment court comes in? A lot of questions have heretofore been not answered. Yes, there is a view that the Senate is a continuing body and therefore can continue to hear the impeachment complaint. You know, there are a lot of opposite arguments can be raised, as in this is not in the nature of a investigation by Congress, but you know, it's an investigation of the impeachable offenses allegedly committed by the Vice President. And therefore, the question is, can the question of the mandate of the present Congress when it expires, etc. So this is an issue which I don't pretend to be able to answer right off the bat, and maybe the colleagues of Chit here in the Supreme Court can answer that question better. But it is a question which has not been answered, and that is why I hope that this can be raised so that for us to be enlightened.
Commissioner Sarmiento, would you have a response to this question?
Professor Tamasa, so far as that question is concerned, you have the concurring and dissenting opinion of Justice Carpio. In the case of Garciliano versus House of Representatives, what was his concurring and dissenting opinion? Insofar as all other matters and unpassed bills are concerned, deemed terminated. And he was referring to legislation. So that, with respect to non-legislation, the case of the one I mentioned, Pimentel versus House will come in. Impeachment is non-legislation. So therefore, if it has been started in June 2, 2025, it has to continue when the 20th Congress resumes or opens its session.
Thank you, Commissioner Sarmiento. Professor Rivera, Professor Te, just perhaps to add a little more context to this question, and to be, just to present a devil's advocate position, I think the position of some is that the Senate terminates on June 30, not just from a constitutional standpoint, but also from a democratic standpoint. By the time you have people selecting a new Senate with probably different priorities or policies, does that change any answer that you may have with regard to this question, or how would you respond to this question about impeachment crossing over from the 19th to the 20th Congress?
As Senate President Drilon mentioned, this is an open question. We don't want to prejudice a consideration of that question should it reach the Supreme Court. But at the moment, I think we have three theories on this point. The first is that it may continue into the 20th Congress for the reason that Commissioner Sarmiento had mentioned. The second is it may continue into the 20th, but it will be up to the 20th Congress, specifically the Senate, on whether they will take it up from where the 19th Senate had concluded its work, or if they will restart. And the third, of course, is that it simply does not continue into the 20th Congress for the reason which you stated. So if we look at members of the Senate and members of the House as duly elected representatives of the people, then certainly we must respect the views that may be brought into the question by those who will be duly elected in the 20th Congress, which would then, of course, it's not just a change in the composition. I had heard this as well on a number of news coverage, that there's the view that it's simply a change in composition which should not affect the continuous conduct of the trial, in the same way that, for example, the Supreme Court does not conclude a consideration of any case just because there has been a vacancy that has been filled with a new member. But I think it's very different from a legislative body, which is a representative body, and we should respect, for example, elections are coming, and we respect the vote that each one of us will be making on that day, and that may certainly include a vote on which representative I wish to elect and his view on this particular question. So I think those are the three sort of theories that we have here. But from a strictly legal perspective, we put together what we have based on Supreme Court decisions. It looks like it can continue into the 20th Congress, but the 20th Congress, particularly the Senate, will then have to consider whether it will continue or if it will start anew, which would mean constituting itself anew as an impeachment trial, reconsidering the rules for the impeachment trial, because none of the work of the previous Congress has any conclusive effect on the succeeding one.
Before we go to Professor Te, Senate President.
Let us remember that the Senate is not the impeachment court. The Senate is completely a legislative body. The impeachment court, as we call them, is sui generis, a class of its own. So these are questions which are not easily resolved. And the issue that just like the appellate courts, it can continue to function. You could also make an argument against this proposition that this is not a court, this is not a body which is constituted by law, but it's constituted by a complaint of the House of Representatives, which, by the way, whose mandate would have also expired when this Congress expires. So does the impeachment complaint continue to be valid with the impeachment, with the impeachment complaint authors have lost their mandate because their terms have expired? Marami pong hindi masagot dito. And kaya maganda naman nandito si Senator Robin Padilla. Siguro yung papakinggan niya rito, dadali niya sa Senado po natin yung panahon. Salamat po.
Thank you, Senator Dillon. Professor Te, before you answer, so I understand the hesitance to take up a position in a very difficult open question. I think for lawyers, the difficulty also comes from the fact that impeachment is not really a strictly legal proceeding, and therefore, the idea that law can rise above politics might not be as strong as, let's say, democratic accountability or legitimacy that really goes into the question of impeachment. So if I can, tease you a bit into taking a position, all difficult questions that the court decides are open questions before they get to them. Would you have any particular position on this?
I was about to make the analogy that Senate President Dillon made, that when the impeachment court has been constituted, it is not the Senate. In the same way that the Presidential Electoral Tribunal, once constituted, is not the Supreme Court, even though it is composed of all the members of the Supreme Court. It acts as the Presidential Electoral Tribunal with a different set of rules, with a specific mandate, and therefore, as far as regularity of the schedule, the Senate acting as an impeachment court may not actually be bound by that calendar of session, recess, adjournment, recess, session, adjournment, recess, for purposes of legislative work. And so I would, since you teased me into taking a position, I would probably say that if it is based on that particular characterization of the Senate having been constituted, and I think this is the qualifier I would make, if it had been constituted as an impeachment court while the 19th Congress is in session, and once the 20th Congress comes in, the impeachment court will still stand, having been constituted already, because it is not the Senate acting as a legislative body. The question now of how many members and which members, that is now the difficult question, because practically half the Senate will have their terms ended. There will be new senators. There will be new senators coming in, and so that would have different implications. But I think that would be my position.